Hello, welcome. I'm Amy the attorney, and I am welcoming Maureen Brady. Tell me, what is the name of your law firm and how can people contact you?
The law firm is McShane Brady, and you can contact us via the telephone 816-888-8010, on our website, McShaneBradyLaw.com, or you can contact us through Facebook.
Oh, there you go. Okay, very good. All right, so tell me first, what kind of law are we talking about today? If you were going to sum it up very quickly, this is an area of law. I want you to sum it up how you would describe it.
HIPAA violations.
Okay, so this immediately HIPAA violations, I think, okay, every time I've been to a doctor or sent my kid to a doctor, I have signed a HIPAA violation. What exactly what has happened to this person that is seeking you out, or is that your client now?
Well, what you would have signed at the doctor is something called a privacy notice. The healthcare provider, your doctor, is required to give you notice that you have a right of privacy to your medical information. And by signing that notice, they are laying out certain duties that they have to keep the information private and certain duties that you have to let them know if you want the information released and how you want it released. Those types of disclosures, if it's a disclosure that the patient wants, that's basically fine, and sets the parameters in those privacy notices. If, however, there's a disclosure beyond the bounds of that privacy notice, then there is a violation potentially that the healthcare provider would be subject to sanctions.
Okay. But not necessarily, like when you are going to sue somebody, it's not necessarily you're suing with the HIPAA law. Is that right?
That's correct. HIPAA is actually a procedural statute only. It covers the procedures of how and when information should be maintained private or can be released. The healthcare provider, it just describes what the healthcare provider can do with private medical information. HIPAA also recognizes a general right of privacy. However, HIPAA does not bestow that right of privacy on private citizens. The state law does bestow a right of privacy to citizens and does recognize a duty for doctors and hospitals to keep information private. They just don't say how to keep the information private. So state law provides the cause of action the duty to keep information private. HIPAA comes along and says, here's how you keep the information private.
Okay, very good. That is good knowledge to know. So how would somebody know they needed a lawyer because their medical records were exposed? Because I can imagine that it's not necessarily a situation where they know.
Sure. And typically, the most common way that an individual would find out that their information has been disclosed is what we call nosy neighbors, where they hear through town gossip of those types of things that someone has heard about their information. Oftentimes, though, if there has been a disclosure through an email hack or hack of the computer system, or if there has been some sort of mishandling of patient information, the healthcare provider, the doctor, is required to give notice to the patient that there has been a wrongful disclosure.
Okay.
And they're also required to provide specifics to the patient of what has happened to try to get the information back, what they believe is done with the information, and they are required to inquire of their patient of what harm has happened to the patient because of the disclosure.
So the doctor's office would notify someone that their information is out there.
Correct.
And when you say they will also tell them how it harmed them, drill into that a little bit more. What do you mean by that?
No, they're to inquire of the patient how the patient may have been harmed because of the disclosure.
Okay.
HIPAA provides procedures, and let me just back up. HIPAA recognizes that disclosures happen, and that oftentimes you can't prevent every single wrongful disclosure. There are plenty of disclosures out there, which I call no harm, no foul. Someone disclosed information, realized they disclosed information pulled it back as quickly as possible, got assurances from the person that it was disclosed from that no further disclosure would occur, and everybody's fine.
And that's the end of it.
And it's the end of it. No big deal. But HIPAA also recognizes that there are disclosures where that potentially can harm individuals. So it provides procedures after a disclosure by which the healthcare provider must follow, including investigation, discipline of the person or persons who disclosed the information, investigation to the patient, determination of what harm befalls the patient, and mitigation of the harm to the patient.
Okay.
Oftentimes, what I see more often than not is healthcare providers fall down on those post-disclosure duties.
Of course. All right. So, so tell me, you said you file under state law, and we are here in Missouri and Kansas. That's the target audience of this broadcast. So, are both of those, Missouri and Kansas, do you have a right of privacy under Missouri and Kansas law?
Yes.
Okay. So that, and generally, you're going to bring it in state court rather than federal court?
Absolutely.
Okay.
In fact, these are only state law causes of action. We have brought cases in federal court, but typically those are large class cases where it crosses state lines and basically affects diversity.
Okay. All right. So so somebody finds out, they've either been notified by their doctor that a HIPAA violation has taken place, what they're trying to do to remedy it, and they call you, and I want them to know, what are they asking you? Like, what are the 3 questions that somebody should ask a lawyer that is pursuing a HIPAA violation, a privacy violation?
The first question that I always get is, what can I do about it? And there are a couple of things that the patient can do. First, if they believe that the disclosure was in fact a violation of HIPAA, there is an oversight agency at the state and federal level. At the federal level, it's called the Health and Human Services Office of Civil Rights. That particular office has the job of basically policing healthcare providers who are subject to HIPAA. And if a patient believes there's been a disclosure, the patient can go online and file a form with HHS OCR, because the federal government loves their acronyms, and tell them what happened.
Okay.
Oftentimes, though, what we see for the oversight, so that's a possibility, and I would encourage patients to do that feel that there's been a disclosure, but know that the agency who has this oversight is extremely limited. They are covering the entire country, and they are really going to investigate disclosures that affect 1,500 people or more.
Oh.
So oftentimes it's just a situation where they need to retrain or those types of things, because they really don't have time to fully get down in the weeds with the healthcare provider. That's fine.
Okay.
The second thing they can do, of course, is contact a lawyer, which is exactly what they should be doing.
All right.
And the lawyer is going to be able to tell them if they have a cause of action and discuss with them the various parameters of that cause of action. Oftentimes we've got a situation where we have an individual who has had a disclosure, but really nothing has happened because of that disclosure. And you get the situation where there's a no harm, no foul type thing. The healthcare provider pulled the information back, they locked it down, they disciplined disciplined the employee who disclosed it and notified the patient as they were supposed to. And that's basically not a big deal. Where we see the bigger deal is where there has been a disclosure either by inadvertence, recklessness, not paying attention. Someone, discloses information they weren't supposed to. They thought they were supposed to, but they didn't. And then the healthcare provider has done nothing to help the patient after the disclosure and really has not disciplined the individual who did the disclosure.
Okay.
And under those circumstances, that's where I would get involved. We would ask the healthcare provider to provide us, the attorney and the patient, with assurances that there's been HIPAA compliant duties met after the disclosure and to determine what happened. Also, I would talk with the patient as to what happened as a result of the disclosure. Sometimes we have a disclosure and there's been no, either the information has not been found or there's been no verification that anything nefarious has happened to the information, meaning that the person has no evidence that there has been misuse or mishandling of the information by a third party.
Okay.
However, that's not the determinative of damages because it is all about the patient. The patient's anxiety, the embarrassment, the humiliation, the loss of trust, the loss of privacy, those are the damages that occur from these wrongful disclosures.